Welcome back to Swat&Vee Immigration News. Please don't forget to subscribe if you're new to the channel. In this video, we will explore the major ways that one can lose permanent resident status. Let's get started. Getting a green card is indicative of permanent legal resident status. It is granted to those who wish to stay in the United States for the long haul. However, the journey to getting a green card is challenging and the process is lengthy. And once you have gotten your green card, there is a possibility of encountering situations where you could lose your LPR status. 1. Living outside the United States. Generally, spending more than 12 months outside the United States will result in a loss of permanent resident status. In fact, even shorter absence can trigger abandonment. If upon re-entry, the Custom and Border Protection Officer determines that you intended to live outside the United States, they can put you in removal proceedings. Additionally, failing to file income taxes with the IRS while living outside the US can trigger removal. Each year, many people unintentionally abandon their green card status when they move back to their home country. They may need to take care of a sick family member, attend school, or even tend to their own medical needs. Without the right preparation and planning, it leads to the most common way to lose permanent resident status. How you can prevent it? This is common, as many people unintentionally trigger their green card revocation when going back to their home country. However, this can be easily avoided. Permanent residents planning to leave the country for a significant amount of time should obtain a re-entry permit before departure. This permit is valid for 24 months or 2 years. 2. Voluntary surrender of green card. If you have ever filed Form I-407, you have voluntarily abandoned your status as a lawful permanent resident of the United States. Each year, several thousands of people file Form I-407, record of abandonment of lawful permanent resident status. The most common reason people file Form I-407 is to escape the obligation of paying US taxes. However, anybody that wishes to do this should consult with an immigration attorney and tax professional that can advise them on the long-term consequences of their actions. 3. Fraud and willful misrepresentation. A fraud is generally committed when an individual lies to obtain immigration benefits of some kind. However, any assertion or representation of facts that is not completely truthful can create significant immigration problems and potentially result in the loss of permanent resident status. Fraud can occur when preparing an application, submitting evidence, interviews, or any exchange of information with immigration officials. It can occur in connection with immigration benefits other than permanent residence. For example, extension of non-immigrant stay, change of status, employment authorization, and parole are all immigration benefits that USCIS evaluates for potential fraud. Two of the more common ways to lose permanent resident status include marriage fraud and visa fraud. Let's know about marriage fraud. Marriage has been a long time target of fraud. Marriage to a US citizen is one of the fastest paths to a green card. As a result, dishonest individuals use it as a vehicle to fraudulently obtain permanent residence. Marriage fraud comes in many different forms. USCIS has identified the following types of marriage fraud. 1. Someone pays a US citizen to marry a foreign national. 2. A US citizen marries a foreign national as a favor. 3. A foreign national defrauds a US citizen who believes that their marriage is legitimate. 4. Mail order marriages, where either the US citizen or the foreign national knows that the marriage is fraudulent. 5. Visa lottery fraudulent marriages. Now, let's know about non-immigrant visa fraud. Most foreign nationals applying for a US non-immigrant visa must demonstrate that they plan to return home when they are done with their intended program or activity. This standard, known as non-immigrant intent, requires the individual to have a residence abroad that he or she has no intention of abandoning. The US Department of State uses a 90-day rule to evaluate cases in which the non-immigrant attempt to change status or adjust status to permanent resident. The 90-day rule is a guideline of a sort that there is a presumption of fraud if a person violates his or her non-immigrant status or engage in conduct consistent with that status within 90 days of entry. For example, entering the United States on a B2 visa with a preconceived intent of getting married and filing for Form I-485 to adjust status should be a violation of the visa terms. 4. Criminal convictions. If you are caught committing different crimes or using and selling illegal substances, you will likely be deported back to your country of origin and lose your green card status. In such cases, it is essential to consult with an attorney. Failing to remove conditions on residence. Residents who fail to remove conditions of residence are liable to be deported upon the expiration of their 2-year green card. This holds for foreign nationals who have been obtained their residence through marriage. Upon marriage to a U.S. citizen, spouses receive a 2-year conditional green card for permanent residency. The person must file a petition to remove the conditionality. This document must be filed within 90 days of receiving the conditional green card, or else the card expires. The conditional card cannot be renewed. Please share this information with family and friends who may need it. You can also help us spread the message by sharing it on all social media. Thanks for watching, and don't forget to subscribe and hit on the notification bell for more immigration updates. Bye!